Hi there, and once again, welcome to Employment Hour in 30. I'm John Scholes, along with Lior Samfiru from the Samfiru Tumarkin law firm. If you haven't caught our show before, we talk about employment rights, everything that's important. We weave through the web of employment and the workplace, which can be very confusing, but we'll lay it all out for you every week here on the show over this next half hour. Lots of stuff to get through. We'll get to the Severance Pay Calculator. Contact anytime, of course, 1-855-821-5900 to get a hold of Lior or a member of your team. help@employmenthour.com as well. We're going to get through instances where you may have been constructively dismissed. We'll break that down and define it for you in just a little while. First, though, my friend, we always start with the week that was. What has been happening? You know,
I've had the pleasure and the privilege, John, this week to speak with a lot of people that have had workplace problems and finally felt comfortable that there's something they can do about it. So they've called me, they've emailed me, and we've been able to talk about those problems. So if folks are out there struggling with the situation, well, I probably have a solution. I'm very likely have seen it before. So don't struggle there thinking that there's nothing you could do. Give me a call. Email me. We'll give you my contact information in several ways. I'm always happy to talk. There's no bad questions. Take advantage of the fact that now you know that there's solutions out there to those problems, to your workplace problems. Maybe your boss did something and you want to understand, is that legitimate? Is that okay? Or maybe you're concerned about the security of your job. You think they're going to let you go. Can you prepare for that? What do you do about it? Let's talk about all those things that can help you out. And to get us kind of revved up here on the Employment Hour in 30, let's talk about a situation that came across my desk. I spoke with a gentleman that had been off work for a few months as a result of a bad back. And the company was fine with it, let him be off. He was receiving some disability benefits and finally was cleared to come back to work and was very happy about it. Now, when he came back, or when he told his employer he's coming back to work, his company says, well, we're going to only let you come back to work after you pass a drug test.
Wow.
So we're going to need you to pee in a cup, and only if you pass that test will you then be allowed to come back to work. Now, again, he had a back problem. That's why he was off work. He wasn't off work because of a drug dependency issue. And he wasn't comfortable with that. He said, well, why should they impose conditions like that on me? Why do I have to take a drug test? It's a personal thing. It's a privacy issue. And he called me and he wanted to know, can they do that? Can they say, you're not coming back to work unless you take a drug test? Well, John, the answer is no. They cannot do that. First of all, a company does not have a right to just randomly have people subject to a drug test. That could be a human rights violation. Beyond that, there's really no cause to be concerned here. He wasn't off because of a drug dependency. He was off because of a bad back. There's no reason to think that there's a drug issue here. So in those situations, he doesn't have to do it. The company is not allowed to impose preconditions for the company to meet its own legal obligation. In this case, the legal obligation is to take him back to work. So a drug test generally, and I want our viewers to understand, that is illegal. It's a human rights violation. There's very limited circumstances where a company can impose drug tests or alcohol tests, for that matter, in the workplace. In this case, that's a human rights violation, and their refusal, John, to take him back to work unless he took the test could be a constructive dismissal, which means he could potentially pursue damages here as well as a human rights violation.
Is there circumstances where either midstream during employment, when an employer comes back from, say, some sort of leave, even though it's a back injury, it's not rehab, or leading into a new job, is there times when they can impose a drug test?
Almost never. Right. The only time a company can impose drug tests is if there's a widespread problem in the workplace with drug use, and if the position is like a pilot. We were talking about that the other day. With the pilot, you know, it's such a safety-sensitive position that you can't take any chances. In those limited circumstances, maybe you can impose a drug or alcohol test. In almost every other situation, John, it's illegal.
Over 4 years, almost 5 years now, we've been doing the radio show and radio shows around Ontario. If you haven't caught it, employmenthourtv.ca to find a place where you can catch the radio show. We take a ton of phone calls. We always go into the radio show with lots of content, lots of things to talk about, and it ends up being an entire show of phone calls because people have so many questions about this topic. Want to play a phone call back from that radio show and get you to comment on it.
A friend of mine is going through applying for a job, realized they were pregnant after they started the whole application process, and wondering if it's too risky for them to continue with that application. Is it any easier for an employer to let somebody pregnant go in the probationary period? Because they're going to obviously find out within that period of time.
The old pregnancy phone call.
The old pregnancy situation. Yeah. So this is actually quite straightforward. The fact that she now finds out that she's pregnant does not mean she should not apply for jobs, not at all. Not only that, it does not mean that she has to tell her prospective employer that she's pregnant. There's absolutely no legal obligation to tell your prospective employer during an interview or otherwise that you're pregnant. That's a personal decision which she can make if and when she is ready. She cannot be penalized because she's pregnant. She cannot be penalized because she started a job while she's pregnant. And the company can't say, well, wait a second, you're on probation, so that's why we're letting you go. If the company uses probation as an excuse to terminate someone when the reason they're really terminating them is because they're pregnant or going to be taking a maternity leave, that's illegal. A probationary period is not going to help the company. So the law stays the same. If you're working somewhere and you're let go because you're pregnant or because you're going to take a maternity leave, there's nothing that the company can use to justify that. They can't say probation, they can't say cause, they can't say unrelated. The onus is on them to prove it. So no, I would say absolutely apply to the job. Tell your employer if and when you're ready, and that should not stand in the way at all.
When you, on that note, do you tell prospective employees who are applying for jobs or become pregnant, do you say, you know what, you might just want to be kind of cool about it and tell them that you're pregnant, you know, heading into this, or tell them maybe before you go off a week on a maternity leave?
You know, here's what I'll say. You know, I'm a realist, and I've seen enough situations where if a company believes or thinks someone is pregnant, they're not going to hire them. So I would never say to an employee applying for a job, tell them that you're pregnant. That's a personal decision.
Right.
The reality is, if you tell them, you probably are not going to get the job. But certainly, I do believe in, once you're already employed, to give the employer as much notice as possible of the pregnancy and letting them know when you'll be taking maternity leave, to give the employer the opportunity to plan accordingly. Now, you don't have to do that, but I think that is good practice, and that shows that you're a team player. But that is a personal decision, and if someone's not comfortable telling their employer until later on in the process, that is just fine as well.
Phone calls, emails, help@employmenthour.com, by the way, is the email address. There's also terminationquestions.com as well. That is a site where you can ask a question via drop-down menu. There's a very high probability that your question has already been asked and answered by you or a member of your team. But just in case we had to read some on the air, get some perspective on it, again, terminationquestions.com is that website. Says here, after 5 years of flawless work, I missed my sales target by a tad last month, just a bit. Now I'm on a performance improvement plan. Can I refuse their plan, or would that count as insubordination, allowing them to fire me for cause?
Yeah, no, very, very good question. And performance improvement plan is something that a company does, as the name suggests, to help someone improve their performance, someone whose performance is lacking. So the first thing I would say is, if you don't agree that you should be on a performance improvement plan, if you think you've done everything you can or should do as part of your job, and maybe the fact that you didn't meet the target is not your fault, if that's the situation, then say so. But if the performance improvement plan is otherwise legitimate, you didn't meet the target, yes, you should follow it as long as it's reasonable. If they're asking you now to improve your performance, you have to work 18 hours a day, 7 days a week, well, that's not reasonable. But if what they're asking is reasonable, you should do it. And a failure to follow a reasonable performance improvement plan can be cause for discipline, at least. Maybe not necessarily dismissal. It's very difficult to let someone go for cause, but certainly cause for discipline. So yes, follow the plan. If you don't agree with it, say so, and say so in writing. And certainly, if the company decides to let you go, let's assume that you follow the plan and you still can improve the performance. The company decides to let you go for cause. Remember, that does not mean that there's cause. The fact that your performance was lacking, the fact that you followed the performance improvement plan and the performance still did not improve, does not mean that there's cause. Cause is very difficult to establish. It's the worst penalty. The company would really have to show that you went out of your way to be a bad performer before they can let you go for cause. So in other words, if you're let go, you're going to be owed severance.
SeverancePayCalculator.com. We're going to cover this in detail a little later on the show, but I did mention off the top, one of our topics for today is you may have been constructively dismissed if ... We'll get to a few of these and let you expand on them. Number one, if your employer changed your compensation or salary, or general change. Right?
Yeah, general change in the terms of employment. A lot of people have heard this term, constructive dismissal, but we want to talk about what it is, when it happens. It's not always obvious. Generally speaking, John, a constructive dismissal happens when the company changes the terms of your employment in a significant way, and that gives you the right or the option to treat your employment as being terminated. So if you're experiencing a change, then yes, you may be able to say to your employer, I'm not accepting that change. I'm going to treat that as a termination and leave. Probably the biggest or most common form of a constructive dismissal is changes to compensation or changes to the job. If your company reduced your pay or demoted you, then in most cases that would be a constructive dismissal, certainly if the change is significant. So you don't have to accept a change to compensation, and the risk of accepting that change is you may be able to, or maybe put in a situation where the company can do it again in the future.
Because you accepted it.
Because you accepted it. So don't let the employer do that, and if you're faced with a change in compensation, give me a call. I don't want you quitting before you do anything. Let's talk first, but that may well be a constructive dismissal.
You know, it's funny, you mentioned change in compensation. Could that be not only the amount of compensation, but say you are a salesperson and you've always worked on 100% commission. Now they're going, we're going to switch it to base plus commission. You may come out whole in the end, but you're like, I don't know if I like that so much. I'm a pretty aggressive sales guy. I prefer 100% commission.
Yeah.
Does that qualify?
A change in compensation structure, which is exactly what you've defined there, is absolutely or can absolutely result in a constructive dismissal. So even if the net compensation is not obviously different, if the structure of the compensation is different, so maybe you have less potential to earn, that absolutely can be a constructive dismissal. A company does not have a right to say, I'll take commission or replace that with a salary, or take the salary, replace it with commission. That is a significant change. Anytime compensation is being changed in any way, we're automatically thinking of constructive dismissal.
Email is help@employmenthour.com, and 1-855-821-5900 is the number anytime. We're talking about times you may be constructively dismissed, if, here's another one, you get phone calls all the time, your employer moved your workplace to a new location.
Right, and when we're talking about that, we're not talking about my desk was moved from office A to office B. We're talking about the fact that now I have to travel further because they've moved our office somewhere else, or our workplace. So generally speaking, if you now are in a situation that is a result of the workplace change of location, it's going to take you a lot more time to get to work. It's going to impact your life in that way. Then that's obviously a big deal. It's a significant change, and you may be able to say, no, company, I'm not going to now commute to this new location. Because of this change, I'm going to treat that as a constructive dismissal and leave. It's not every change in location that results in a constructive dismissal. If the change is minor, if the office moves across the street or 5 minutes away, it may not be a constructive dismissal, but certainly any big change where it's going to impact your commute in a significant way, constructive dismissal.
So they have a bit of leeway, but if you now have to take 3 buses and a streetcar rather than just taking one, I mean, that's a big change.
Absolutely. And if I don't drive, for example, and I just take public transportation, well, then for me, even a small move may be a big deal for me. So that could be a constructive dismissal. If you drive, for you it might not be a big a deal. So for you it may not be a constructive dismissal. So every situation is different.
Another situation where you may have been constructively dismissed is your work environment has become poisoned and they're not doing anything about it. I'm thinking my mind goes right away to workplace harassment, especially in this climate, right?
Yes, so workplace harassment, where an environment that's not conducive to working, is another way where you can be constructively dismissed. There's an implied term in all our employment relationships with employers that we're going to work in a supportive and proper work environment. If the work environment becomes poisoned, if the company won't do anything about it, you're subject to harassment, you've complained, and the problem is still there, it's not fixed. Now you're in a situation where it's difficult to go to work. That is a constructive dismissal. You may be able to say, no, I don't have to take this. I don't have to suffer and then go to work and be harassed. I can leave and get severance because you, company, didn't do anything, so you owe me severance.
What if it's maybe, it could be a large company or a small one for that matter. What if the harassment or harasser is the boss, the guy you're supposed to report this to? Happens, right?
If you can't report it because it's the very person at the top of the food chain that's the one doing the harassing, then that is probably going to be a constructive dismissal right off the bat. We can deal with that externally, get you out of there and get you compensation. That's a classic constructive dismissal.
Times you may have been constructively dismissed. Couple more on our list that we'll cover here. You were demoted or saw responsibilities taken away from you.
A demotion with or without change in compensation often results in a constructive dismissal. I'm speaking right now with a lady whose compensation hasn't changed, but her responsibilities were taken away. She used to have a few people reporting to her. Now she doesn't. It's a clear demotion. So if you've been demoted, it's a lesser position. Even if your compensation hasn't changed, you don't have to accept that. The company does not have the right to do that. That absolutely, John, is a constructive dismissal.
And the last one for constructive dismissal, you may be in that situation, is simply you were put on a temporary layoff. We know that one.
A temporary layoff is a situation where the company says, I don't have work for you right now. I'm going to send you home and hopefully call you back in a few months. So, John, if I were to tell you I reduced your pay by 30%, it would be clear that that's a constructive dismissal. Well, a temporary layoff is a situation where I've reduced your pay by 100%. That's why a constructive dismissal or a temporary layoff is a constructive dismissal. The company does not have a right to do it. If you've been put on a temporary layoff, you have the right in most cases to treat that as a constructive dismissal and leave with severance. Unless, of course, the company's done it before and you've let them do it, then there's an implied term. But if this is the first time you've been put on a temporary layoff, you've actually been terminated. There's no legal right to lay you off temporarily.
Is there situations, I'm not going to say there are, I'm going to ask you, is there situations where maybe the job dictates that it's a temporary layoff? I'm thinking pool cleaners, maybe roofing for the middle of winter, right?
If you're working in a job that's understood that it's a seasonal job, right. It's understood that you're not going to work, let's say, through the winter, then yes, the company could then lay you off for the off season because that's the nature of the job. But the company can't say, well, it's the nature of the job if they've never done it before and this is the first time. Well, if it was the nature of the job, they would have done it every year. So don't assume that something is implied. If it is implied, then it would have happened consistently. If this is the first time you've been laid off and there's no history, you've probably been terminated.
You want to contact Lior anytime, 1-855-821-5900 or email help@employmenthour.com. We'll take a short break. When we come back, I mentioned it, Severance Pay Calculator. We'll get right into that. And fired for being not the right fit. Is that a constructive dismissal? That and lots more coming up on Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. John Scholes, Lior Samfiru. We mention this all the time. We are closing in, I think, on close to 500,000 users of the Severance Pay Calculator. So a lot of people have been enlightened to a great degree about how much their severance should be. Give me some details on it. We'll get to an example as well.
Half a million people. That's a lot of people. So if you haven't used it, you're kind of late to the party, but that's okay. You can still use it. SeverancePayCalculator.com is a website that I created, John, to help anyone find out immediately, right now, how much severance you're owed. It's anonymous, it's free, there's no strings attached, you don't have to put in your name, the company's name, so no one's going to find out. SeverancePayCalculator.com. 3 questions is all you answer. The length of your employment, your age, and your position, and you are done. Use it right now. Get your phone, get your laptop, go to SeverancePayCalculator.com. I promise you that the amount of severance that you think you would be owed if you lost your job is a lot less than what the law says you should have. If you lost your job, the first place you go to is SeverancePayCalculator.com. If you know somebody that they lost your job, you're talking with your friend across the street, let them know as well. Don't let them accept inadequate severance. Tell them to go to SeverancePayCalculator.com.
Try it. It's easy, and even just for interest's sake, give it a shot, give it a whirl, and you'll be surprised with the result that comes out. Right?
Most people that find out about it go use it right away because they're curious. All of us have an amount in mind. We think, well, I'm pretty sure that if I lost my job, they'd owe me this much. Well, don't assume. You don't have to assume anymore. Use it right now. And certainly, if you're looking at that severance letter, they've offered you 6 months' pay. You want to know if that's okay, if that's proper. Don't worry about it. Go to SeverancePayCalculator.com. Answer those questions, you find out right away.
I'll read an example for you and let you expand on it. After working 16 years as a roofer, making $52,000 per year, Carl was fired last week. No severance offered. There's a shock. He called the Ministry of Labor, who told him that because his boss had a payroll under $2.5 million, he's not owed anything. Why does the Severance Pay Calculator suggest that he is owed severance pay?
Yeah, and that's exactly a question that we got. We're reading an actual situation email that I got. So let's make it very clear. This whole $2.5 million payroll is only relevant with respect to someone's minimum entitlements. It's completely irrelevant when it comes to a person's full entitlements, what we call their common law entitlements. So if you want to know how much you're actually owed or how much the company has to pay you, the size of the payroll does not matter. It's exactly the same whether you work for a big company or a small company. Unfortunately, the Ministry of Labor can only advise you with respect to your minimum entitlements. Again, that's a small fraction of what you're actually owed. So because of that, you cannot and should not call the Ministry of Labor if you lost your job. So let's actually take this information that you've just read to us and let's put that in our severance calculator and let's see what that gives us. Remember, Ministry of Labor said he doesn't get anything. What does he really get? So he's a laborer, a roofer, so we put that in there. 16 years of service. I picked an age at random, say 54. Salary of $52,000. Ministry of Labor says he doesn't get anything. He actually gets, severance calculator says, 16 to 18 months of pay. Months.
A year and a half from nothing.
So that could be $80,000 or so instead of nothing. And that happens every day. People either miss or don't understand their rights or call the Ministry of Labor and get incorrect information. Hopefully you understand now the difference between 0 and 80,000 is significant, which is why I say you have to go to severancepaycalculator.com.
You mentioned Ministry of Labor a couple times there, and we should just warn people on the side that starting a file with them in this case is not a good thing to do.
If you say, okay, well, I want you to help me, Ministry of Labor, and you ask the Ministry of Labor to get your entitlements, number one, they can't do it. Number two, by virtue of filing that document with the Ministry of Labor, you're now prevented from actually pursuing your entitlements. You're stuck and you've given up your rights. What a terrible situation. So please don't do that.
Phone calls, 1-855-821-5900. Email or at least phone call Lior directly or the firm. Also the radio show, if you haven't caught it over the last half a decade, we've been doing that. How does that feel?
Long time.
A lot of gray hair here. You can catch at employmenthour.ca to find out where you can find the show. Listen to the show on the radio. We take a bunch of phone calls every week. We'll play one back and I'll get you to expand and comment on that.
I've been employed for almost 5 years, a little over 50. They terminated me. I had no notice, and when I asked them what the reason was, specifically, they said, you're just not a right fit. And I said, is there something specific? Is it something bad I did? They said, nope, you're just not a right fit. It was just gone. That's it. Is that basically it? They just say you're not a right fit as a standard wording they just use now?
Yeah, and a very common situation, in fact, common words that employers use, not the right fit. So let's break this down. An employer is allowed to let you go because it feels you're not the right fit. Sure. An employer can let you go pretty much for any reason. That's maybe unfair. I get it, but it is legal as long as they pay severance. So in this situation, if this person was not really told why, just that he wasn't the right fit, that may make his employer not a very nice person.
It may sting a bit, but...
Yeah, it may sting, and it would for me, it would to you, I'm sure, as well. But it's not illegal. The real question here is how much severance are they paying him, and are they paying him the right amount? So yes, you can be let go. The company doesn't even have to, unfortunately, be that nice about it, but they have to pay you severance. And after 5 years, he could easily be owed 6, 7, 8 months of pay. That's what's at stake here. And if they didn't give that to him, that makes it a wrongful dismissal.
We'll talk about non-competition agreements and severance pay for contractors when we come back from a short break. 1-855-821-5900. Help at employmenthour.com as well. It's Employment Hour in 30 right here.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact. The labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. Thank you for joining us this week on the show. You want to contact Lior anytime when the show is not on. Help at employmenthour.com. The number 1-855-821-5900 as well. We do the radio show all over Southern Ontario and other places as well. If you haven't caught it, employmenthourtv.ca. It'll direct you where you can catch that radio show. Phone calls aplenty every week on the show. People have questions. They just don't know. They're in the dark. So we answer as many as we can. We're on the radio, and we'd like to get to a couple during this half hour as well and answer them. Here's another one.
I was let go with no warning after just under 4 years of service. My question is, I only got 3 weeks of severance. I didn't get anything else. I'm just wondering if I'm entitled to anything more, perhaps. I'm 58 years old. The job was a customer service rep.
Yeah, wow.
Based on age alone.
Common.
Yeah.
Of course he's going to be owed more. So, yes, 3 weeks pay, that is a wrongful dismissal because he's owed more. So, again, regardless of the reason why he was let go, the company can let him go, but they have to pay severance. So the real question is, does he get or did he get enough severance? So let's assess that. I can give you the assessment, but let's do the same thing that all our viewers could do. Let's put that in the severance calculator. Right. So the customer service representative for 3 years, 58 years old, he said he got 3 weeks pay. Well, the severance calculator correctly says that for him it will be anywhere from 3 to 6 months pay. And I can tell you, John, that given his age, it would be closer to 6 months than to 3 months. So the difference here is the difference between 3 weeks pay and potentially 6 months pay. That's a huge difference. And there's, I sounded like Donald Trump there for a second. I scared myself. But that aside, that's a common situation. I get this type of questions all the time. People offered pennies on the dollar. There's nothing unusual about it. The good news is, John, it could be easily resolved. These are not difficult situations to resolve. They're very quick. So if you're in that situation, like this gentleman that left us the message, give me a call. Let's talk about it. Let's make sure that I help you get everything that you're owed.
You know, it's smart, too, that he made that phone call, because otherwise he might have talked to his neighbor, brother-in-law, his son, said, no, 3 weeks, you're good. You weren't there very long. 3 weeks, for sure. That's bang on, because I don't know.
That's why we started doing the show. Right. That's why I created the severance calculator, because people were going to the wrong places to get employment law legal advice. Now you don't have to do that. You know my contact information. You know about the severance calculator. No more excuses.
As I mentioned in the last segment, terminationquestions.com, another resource for you to answer questions, have them answer, or ask questions, have them answered by Lior, or a member of his team. We'll get to another one of those from terminationquestions.com. Says, I've just been let go after 4 years due to quote-unquote restructuring. I accepted the standard severance offer of 4 weeks pay, standard severance offer. The paperwork I signed included a non-competition agreement stating that I need my employer's permission to work for a competitor anywhere in the province over the next 12 months, a complete year. How am I supposed to find work now?
Wow. John, I don't know that I could have given you a better example as to why someone should not, under any circumstances, sign a severance letter without getting advice. So what does this person do? So he worked for 4 years and he accepted 4 weeks pay. He probably was owed 6 months pay. So before we even talk about the non-competition obligation, this guy's getting pennies on the dollar. The problem, by the way, John, as you know and our regular viewers know, is once you've signed off on that severance letter, in almost every case, you're stuck. You can't do anything about it. Ship has sailed. So that's problem number one. He could have been owed another 5 months pay or so, or more. But beyond that, what the company did, which is nonsense, frankly, is they put in the severance letter a non-competition. So we'll pay you a fraction of what we owe you, and for us to pay you that, you have to agree not to compete with us for a year. My God, that is nonsense. But the problem is he signed it. And the fact that he signed it may mean he now has to deal with it. So here's how this works. It may be unenforceable, that non-compete. It may well be. Most are. Not all, but most are. But the problem is that because you signed it, the company may try to enforce it. Okay. So the best advice is either you're going to comply with it or talk to your employer and try to get them to release you from that obligation. Give me a call. I may be able to help you with that. But the best thing I can say is don't make the same mistake. You know, if you're watching us right now, please don't sign off on a severance offer. This person got a fraction of what he was owed and potentially gave up his right to work for a year. What a terrible situation. He didn't get legal advice.
Got about a minute to go in the show. Quickly, what could the company do? Worst case scenario, if you just said, you know what, I'm going to go get a job tomorrow. I don't care about your non-compete.
Well, it's very simple, John. They'll sue him. Wow. They'll sue him. They'll sue his new employer, and they're going to make his life miserable. And that's a terrible situation. It's going to cost him a lot of money, even if he wins, and he probably will win at the end. That's why we never, John, ignore non-competition obligations.
Enough for this week. Lots more to go every week here on the show. If you haven't caught the radio show, employmenthourtv.ca is the place you want to go for that. There's lots of resources there as well. The radio show every week for the last 5 years. And Severance Pay Calculator, again, to reiterate, give us some details on that before we go.
You lost your job. You're worried about it. You may be thinking something is coming down the pike. SeverancePayCalculator.com. Remember, you can't do anything about the reasons the company let you go, but you can and you should and you must do something to make sure that you get everything that you're owed. SeverancePayCalculator.com.
Super quick, super accurate, and completely anonymous. There's a button at the bottom you can press if you want to contact Lior's team. Other than that, you just go off like Kaiser Soze. Nobody knows you were ever there. 1-855-821-5900 is the number to contact Lior and the firm. And as always, there is email, help@employmenthour.com. Till next time, it's been great. We'll see you next week right here on Employment Hour in 30.